Unpaid partner in the matter of Lewis-Ranwell and G4S Healthcare Ltd.
Yes, Mr. Devon.
Ladies, my lord. At its core, this should be a straightforward case. It involves, we say, the orthodox application of established principles concerning the illegality defence in support of sound public policy based on contemporary values. A little bit of the facts. In November of 2019, after a 2-week jury trial, where the only issue was Mr. Lewis-Ranwell's state of mind and whether he was to be found guilty of diminished responsibility manslaughter or to be acquitted and found not guilty by reason of insanity. The jury in that case did 2 important things. Firstly, they unanimously found him to be not guilty by reason of insanity, and specifically on the basis that he did not know what he was doing was wrong. And secondly, they sent a note to the judge, Mrs. Justice May, expressing concerns at the state of psychiatric service provision in their county of Devon, and they asked for reassurance from the court that the failings in care, as they described them for Mr. Lewis-Ranwell, would be addressed appropriately following the trial. And just for your note, that note is referred to in the transcript of the Crown Court trial at page 107 of the supplementary bundle, which is at tab 10 of that bundle. The claimant, Mr. Lewis-Ranwell, seeks to litigate those same failings. And in March of last year, in the same courtroom where the criminal court trial had taken place, courtroom 1 of the combined court centre in Exeter, the defendants sought to bar the claimant from bringing the claim, and they did so on the basis of a defence which rests on illegality and or immorality. Mr. Justice Garnham, we say, rightly refused that application. The attribution of culpability is essential to the defence of ex terqui causa, and by reason of the not guilty verdict, on the basis that Mr. Lewis-Ranwell was insane and did not know what he was doing was wrong, no such culpability can attach to him. The effect of the defendant's argument is that it is not necessary to attribute any culpability to the claimant in order to engage or enliven the illegality defence. That's certainly a novel point in my submission. To have struck the case out would, we say, to have led to inconsistent decisions as to the claimant's culpability in the same courtroom between the civil and the criminal law within a very short space of time and in relation to the same person. It would have contradicted the reasoning in the cases of Clunis and Gray and Henderson, which were taken to yesterday, and it would have introduced some incoherence into that reasoning or into the law. And so
just on the question of what happened at the trial, I understand what you say about what the jury's observations were, but the issue of the culpability or otherwise of whether you're talking about the defendants or anyone else, apart from Mr. Ranwell, wasn't the list before the court, or the jury for that matter.
I'm sorry,
it wasn't the issue before the court.
With the issue which the jury had to decide.
Yes.
No, it was not the civil question about litigating claims. I appreciate that. No, the issue before them, of course, was whether was his state of mind and whether he was guilty or not.
That's right.
Yes, I'm sorry if I...
But it goes to the question of inconsistency. I can see from what might be regarded as a bystander's view, that might be an argument, but we're looking at the legal issues that underlie them.
Yes. My submission relates to the subsequent attempt to strike it out, and it is inconsistent, you say, with to have had a finding on one hand that he was did not know what he was doing was wrong and was not criminally culpable, and to try to seek to strike the case out on the basis that on the basis of a defence which requires either that he knew that he was doing was wrong or some culpability and or an illegality.
Yes.
We say, I'll briefly round off these general submissions at the beginning, but we say not only would it have done that, but it would have been introduced some incoherence into the reasoning of the civil law, and it would have extended the reach of the draconian illegality defence would have extended the reach of that illegality defence more widely than is warranted by the demands of justice or by the principles encapsulated by the ex-terpi policy, which, as we understand it, is that the court will not entertain a claim brought by someone based on his own wrongdoing. And we say in doing so, it would have, to have struck it out, would have ignored the public interest, very real public interest, in enabling those failings in psychiatric care, which we say led to the death of all three innocent men. It ignores the public interest in enabling those failings to be litigated and lessons to be learned. My lady, the structure of my submission, I know, is going to develop with your permission. It broadly follows that of my skeleton. Starting with a review of the recent or relatively recent cases where the question of homicide by mentally disordered people has been considered in the context of the illegality defence. Secondly, and in doing that, I hope I've never suggested that the ratio of those scores was that it would apply in an insanity case, but highly persuasive reasoning is central to this. But alongside reviewing those, we'll go back to the case of Hunter and Preslin, which is the Australian authority to which you were taken yesterday by Mr. Warnock, and other authorities referred to in there to bring that up to date in relation to this question of the need for culpability or knowing wrongfulness in the illegality defence. Secondly, we would turn to look at the finding of the judge, in fact, that there was no turpitude here sufficient to enliven the defence. And that's in two parts. Firstly, important to understand the criminal law and Mr. Lewis-Ranwell's criminal status, legal status, and to consider the implications of the two defences and the relevance and function of the hospital order. And secondly, to turn to the question in a little more detail as to what is turpitude and the judgment, particularly of assumption in the laboratoire and apotex. And then thirdly, turn to consider the question of public policy and the application of Patel and Mercer. It won't surprise you to know that we say, first of all, if there is no turpitude, the question of when the defence should apply does not arise. Patel and Mercer is not, we say, it doesn't provide a test which tells you whether there is a potential turpitude. What Patel and Mercer does is says once you have your potential turpitude, the question of whether to apply the illegality defence or not should be considered in this disciplined, policy-based way. The second submission there will be that in light of the previous cases, it wasn't necessary for the judge to undertake an elaborate analysis of the trio of considerations. But nevertheless, he did properly identify the policies and its application to an insanity case, and that led to the result as it would, even if you considered all of them in detail, elaborately and afresh. So I'm starting then with previous authorities concerning homicide. You were taken, of course, to Henderson and Dorset care yesterday. But that is fewer than 3 years ago that the Supreme Court, sitting with a panel of 7 judges, considered when to apply the illegality defence to a claim where a claimant had killed while psychotic. And they considered that in the light of the modern law of ex terpi, in the light of Patel and Mercer specifically. That was the central question in Henderson. And the answer of the court, my submission is hard to read it without coming to this. The answer of the court was to confirm a clear line between cases involving diminished responsibility manslaughter and insanity cases. And we say the present case concerns the application of that boundary.
You're going to show us the passages that you say do that,
I will
because
do.
it isn't clear to me that they did that.
I hope I'll show you that. In seeking to overturn the decision, we say that the defendants wrongly characterised this case as materially indistinguishable from Henderson. And they do that by disregarding the reasoning in the cases and by minimising the difference in criminal law between diminished responsibility manslaughter and an acquittal on grounds of insanity. Because it takes a little while to go through each of the cases of Clunas, Gray and Henderson, and takes the odd detour on the way, I just want to summarise very briefly where I say I'm going in relation to that, and then come to look at Clunas in more detail. In Clunas, Lord Justice Belden, giving the judgment of the Court of Appeal, drew a line between diminished responsibility manslaughter cases and insanity cases, and found that Mr. Clunas could not rely on the illegality defence because the defence requires knowing wrongfulness, and this was a diminished responsibility manslaughter case, and specifically not an insanity case. In Gray, we say, another diminished responsibility manslaughter case, the same result followed. It's right to say that in that case, Lord Hoffman identified that Clunas suggests an insanity case would lead to a different result, but he declined to comment further on the point, noting the authority of Hunter and Preston. In Henderson, the third of the manslaughter cases, the Supreme Court confirmed that respect for the dividing line and approved Clunas. And it declined an invitation to move away from the criminal test and develop the civil law's own approach. Of course, Gray was considered in detail, and the Supreme Court in Henderson confirmed that the key consideration, as far as the majority were concerned in Gray, was this dividing line. The claimant was criminally responsible for his acts. He had been convicted of manslaughter. He had been punished and sentenced on the basis of manslaughter. It was not an insanity case. They used the same phrase. And so Mr. Gray must be taken to have known what he was doing was wrong. Paragraph 105, but I will come to it in detail. So our submission, the effect of our submission is that if there was doubt about that dividing line following Gray, Henderson approves Clunas and interprets Gray as having done the same. Can I ask you to turn to the case Clunas, which is at tab 17. Apologies, I've just been locked out.
I've got the, I've got it up on my screen, it's 282, the electronic one.
Yes, thank you.
I don't know which, which tab it's in.
17 in volume 1.
Yes.
In this case, Lord Justice Belden concluded that the illegality defence was restricted to cases in which the person seeking redress must be presumed to have known what they were doing was unlawful. And he does that on the basis of a review of a number of the authorities, which for your note you can see at the authorities bundle at page 290H to to 292. F.
Yes.
We'll see those authorities referred to in Hunt and Presler, and if I may, I'll take you through them in more detail at that stage. But suffice it to say at this stage that he concluded, on following that review, that this matter, that he concluded that the person seeking redress must be presumed to have known that what they were doing was unlawful. And he cites what Lord Kenyon had said in Merriweather and Nixon, describing that as...
So, sorry, which page are we now on?
As based on... sorry. Seem to have got a different line. 292.
Yes, I've got it to my 291
Yes, thank
at
you.
letter E.
And at 291, yes, D to E. It's from he's citing...
From Lord Best, from Chief Justice Best in Adamson and
Jarvis.
Jarvis. Yes, I see. Yep, thank you.
In reason, justice and sound policy, the rule that wrongdoers cannot have redress or contribution against each other is confined to cases where the person seeking redress must be presumed to have known that he was doing an unlawful act. And he goes on then at paragraph 293 to apply that to the specific, page 293 at paragraph E, to apply that principle which he has accepted to this case, to the case of Mr. Clunis. And you'll see that he's saying at the bottom of page 292, these principles seem to us to be relevant to Mr. Owen's next position, that not all criminal or illegal acts will prevent the court from entertaining the plaintiff's claim. He talks about there being trivial cases. And at that point, Lord Justice Dudley goes through the reliance cases and so on. But to move on to 293 E, he applies it here. In the present case, the plaintiff has been convicted of a serious criminal offence. In such a case, public policy would, in our judgment, preclude the court from entertaining the plaintiff's claim, unless it could be said that he did not know the nature and quality of his act, or that what he was doing was wrong. The offence of murder was reduced to one of manslaughter by reason of the plaintiff's mental disorder, but his mental state did not justify a verdict of not guilty by reason of insanity. Consequently, though his responsibility for killing Mr. Zito is diminished, he must be taken to have known what he was doing and that it was wrong. A plea of diminished responsibility accepts that the accused's mental responsibility is substantially impaired, but it does not remove liability for his criminal act. We do not consider in such a case the court can or should go behind the conviction. A plain reading of that in my submission shows that it's clearly the view of Lord Justice Feldman that the corollary would apply. If it was an insanity case and the claimant did not know what he was doing was wrong, then the defendant would not be successful in launching the illegality defence.
Is it your submission that if Gray and Henderson hadn't supervened, we would be bound by Clunis as a matter of authority to hold that the defence of illegality wasn't available in an insanity case as opposed to a diminished responsibility case?
It hasn't been applied to an insanity case before, so I think it's difficult to go so far as to say that that is the ratio. And I wondered
I think
about
what you're submitting is that the reasoning is very persuasive.
Yes.
Yes.
Because the court took the view that in a case where responsibility was severely, even where it was severely diminished, because it was a criminal act and there had been a conviction, that the claimant in that case could not rely upon, or the defence of illegality precluded him from bringing the claim.
Yes, and that was based on reasoning beyond just the fact of the criminal conviction, but on the fact that in order to launch an illegality defence, to engage the ex terpi policy or principle, it is important to demonstrate that a claimant did something wrong, was culpable in some way. And here the claimant had established, or in our case, the claimant has established that he did not know what he was doing was wrong. And that was in the mind, I understand from the judgment, of the Court of Appeal. And they said, well, he didn't know, if he didn't know what he was doing was wrong, then it would be different. But in this case, Mr. Clunis did know what he was doing was wrong, as we presumed to have done. So it's fundamental to the reasoning, both in relation to the offence, the criminal offence, and in relation to the illegality defence. In grey, and that's at tab 22, Lord Hoffman held that the defence applied on both a wider, the defence of illegality applied on both a wider and a narrower basis. If I could take you to,
yes,
if I could take you to the authorities bundle at page 485, paragraph 32.
The tab.
It's tab 22.
Which bundle is that in?
That is in the.
Got it. I've got it. Thank you. Thank you.
And I'm looking at paragraph 32. And this is in the speech of Lord Hoffman. The particular rule for which the appellants contend may, as I say, be stated in a wider or a narrower form. The wider and simpler version is that which was applied by Flo J. You cannot recover the damage which is the consequence of your own criminal act. In its narrower form, it is that you cannot recover for damage which is the consequence of a sentence imposed on you for a criminal act. I make this distinction between the wider and the narrower version because he has different justifications in relation to the narrower version. That's about public policy. The point I'm seeking to underline here is that whilst there was a wider and a narrower basis, what is absolutely clear is that Lord Hoffman is relying on the criminality of the conviction and of the sentence. It's the legal characteristics of the act on which he's relying, and the legal consequences of that criminal act.
But no doubt at some point that's convenient to you, you'll be addressing the question of what happens where there is a lawful detention.
Yes.
As there is in this case.
Yes.
Which has a statutory underpinning.
Yes. My lady, I was going to wait a little bit to go through these authorities and come to that.
Yes.
That's certainly very important. I can go there first.
No, you absolutely follow your own route. But I should say that in the light of your focus here on consequence of your own criminal act, I mean the public policy again, and the question of the conflict between lawful detention on the one hand and getting damages for that on the other.
Yes.
You can take a step back and take a broader view than that which is expressed in paragraph 32.
Yes.
Even looking at the narrow interpretation of the rule.
Yes, I understand. At paragraph 42 of the judgment, which is at page 488.
Yes.
Lord Hoffman refers to the Australian case of Hunter Area Health Service and Presland, New South Wales Court of Appeal. And you'll remember from yesterday that where the claim, that in that case the claim had been dismissed, notably after a trial of the facts, but on grounds of public policy, despite the claimant's acquittal of the charge of murder on grounds of mental illness. In looking at this case, at paragraph 42, Lord Hoffman says this: it should be noticed that in Hunter and Presland, the New South Wales Court of Appeal, again by a majority, Scheller and Santo, the justices were together, and Spielberg, Chief Justice, was dissenting, went even further and applied the rule. The rule he's talking about is the ex-Turpay Council. Went even further and applied the rule when the plaintiff, who had been negligently discharged from the psychiatric hospital, was acquitted of murdering a woman 6 hours later on the grounds of mental illness, but ordered to be detained in strict custody as a mental patient. He then goes on to identify, we say correctly, the dicta in Clunas. There are dicta, for example, in the passage I quoted from the Clunas case, which suggests that the rule does not apply when the plaintiff, by reason of insanity, is not responsible for his actions. But the majority regarded compensation, even in such a case, as contrary to public policy. In fact, in our submission, that Hunter is not authority for the proposition that the ex-Turpay Hauser principle applies to a case of insanity.
Don't think anyone's suggesting it is.
I think that was an initial suggestion earlier, but as I understand my learned friend's submissions yesterday, what the defendants seek to say is that Hunter is in effect a modern application of the ex-Turpay Hauser.
Yes, I'm so sorry, I misunderstood. Did you say, I may have misheard you. You were saying, were you submitting that Gray isn't authority for that proposition, or that Hunter isn't?
But Hunter isn't.
Oh, I see. Sorry, I misheard.
Yes.
I'm so sorry. Well, I think people are suggesting it's authority, though not, of course, binding on us.
Yes.
It's New South Wales, not England.
I think this, as I understand my learned friend's submission, it's accepted that, as I think it must be, and I'll go through that in a minute, that the judges in the New South Wales decision did not dismiss the claim on the grounds of ex-Turpay Council. They didn't think that they were doing so on those grounds. What I understand the defendants to be submitting here is that, well, little did they know they were applying a modern version of ex-Turpay Council.
I think I don't think that's certainly wasn't my understanding. I think my understanding from the submissions that were made yesterday by Ms. Ayling was that there were reasons why the judges felt constrained from referring to the principle of ex-Turpay, but they, in fact, when you look at what they were actually doing in that case and the way they approached it, it's though they didn't actually use that phrase, that's actually what they were doing.
Apologies for my clumsy summary.
I think that's certainly that was my understanding.
If I may supplement what my lady said, they did use the language of public policy, and that is what Lord Hoffman quotes them as saying. And once you get to public policy, how you deploy it, whether at the causation route or by the causation route or the ex-Turpay causal route, doesn't really matter. The question is it contrary to public policy?
And in this case, the defendant's application is to strike out Mr. Lewis-Ranwell's case on the basis not of causation or breach, absence of duty points, but on the basis of public policy applied through the lens of ex-Turpay Council. And that, I think, must be an important point, because if that's not right, where are the guns? That in Patel and Mercer, for example, there's an assumption that there is a turpitude to which there's some wrong to which you're applying the policies, and you're looking to see whether there would be an inconsistency because of that. May I take you to the judgments, because I think it is important to see in Hunter that when the judges decline...
By all means. At some point, I would welcome your submission on what the position should be in the pertinent example, as Lord Hoffman calls it, where it is the psychiatrist who is himself the victim. But you may want to do that after we've looked at Hunter than before.
Well, certainly I also think it's fair to say that the context of Lord Hoffman's discussion of this issue was in the context of the principle which we are considering too, of extirpi.
Sorry, I just missed
The context of the discussion of Hunter
Yes.
was against the background of his mentioning clearness first,
Yes.
and him considering the boundaries,
Yes.
the proper boundaries of the principle of extirpi.
Yes. My submission is that the judges in the New South Wales court were also considering policies in the light of that
Yes.
defence, and they undertook careful review of the law relating to the extirpi housing defence, the illegality defence, and they came to their views by reasoned judgments. If I may take you to
Have you finished with Gray?
I was going to come back to it after this.
All right.
But at Hunter, which is at tab 41.
I'm grateful to someone who's produced a slightly easier to read version. Not sure whether it's you or Ms. Ailing who's claiming responsibility, but thank you.
I think it was Mr. Goodcamp.
Sorry, would you mind just going back? Chief Justice Spiegelman was the most senior judge of the court, and he gave a dissenting judgment. But he had undertaken this comprehensive review, and at paragraph 78 of the judgment.
And the electronic bundle number.
Yes, I'm not sure whether you're working from the electronic bundle
I am.
rather than the
Yes.
new. So paragraph 78.
1124.
Right, I'm there now.
He came to the view that whereas here a person has been held not to be criminally responsible for his or her actions on the ground of insanity, the common law should not deny him a right to a remedy. As a plaintiff. And that was his conclusion. But it followed a review of the law which goes over pages from 1121 of the electronic bundle to 1124, or paragraphs 42 to 78.
So
Have you got different paragraphs?
no, they're not the same paragraph. Oh, that's not that precedes. Right? You said that follows.
So that was the conclusion that he came to.
Oh, I see. No, I understand what you're saying. Yes, got it. Thank you.
I ask you just to note that because that is an important to read all of that at some point, but of importance to the issue in this case. May I take you in a little detail to his review, in part because he summarizes more succinctly the relevant principles from a number of cases that he reviews, and more elegantly than I think I would do so by taking you to each of the cases. But if we can start at paragraph 55, page 1121. He's come to the point where he's considering the question of moral culpability. Of particular significance in determining the weight to be given to unlawful conduct is the degree of moral culpability that attaches to the plaintiff's conduct. That consideration is of great significance, whereas here the plaintiff has been held not to be criminally responsible for his actions. And I was going to read on to you from paragraph 57, where Chief Justice Spiegelman reviews 7 different English and Welsh authorities concerning the question of whether moral culpability, or which consider whether moral culpability or knowing wrongfulness are necessary ingredients of the illegality defence. I'm very happy to read paragraphs 57 to 68, but if you would prefer to read those to yourself, then I'll stop here.
Of course, the Chief Justice there makes it very clear at the start of this exposition of the cases that none of them involved the situation in which a defence of insanity was available. And indeed, in an earlier part of the passage you wanted us to read, at paragraph 43, said, say for one United States case, he'd actually found no authority, which in terms considered criminal would otherwise constitute a crime of the utmost gravity, but which was not criminal by reason of the insanity of the plaintiff. So
Yes.
all of these cases are cases which are not, on one view, directly in point at all.
The purpose of taking you to these is that there is no, and I take it to that particular US case that he refers to in a minute, but there is no authority reviewed either in this extensive review or put before the court by the defendants or found by us in our extensive research in this case, which demonstrates that the defence of illegality can arise absent culpability, absent a wrong and a knowledge of wrongdoing. And that
The US cases that are cited in para 68, you've given us one or two, which I quickly looked at in my pre-reading. I don't think they're all of those, are they?
I was going to come to those other.
Yeah, okay, well, then, if you're coming to them later.
If you just stop at the UK cases, so
Yes.
paragraph 57 to paragraph 68, those are 7 authorities where the question of moral culpability was considered and considered to be important in order to found the defence. They include, of course, Clunas. In paragraph 74, Chief Justice speaking returns to this and considering the case of Beresford. And Beresford is a case where the claimant had committed suicide, and the question was whether or not the illegality defence could arise. And the answer to that question depended on the state of the claimant's mind. The question, therefore, is whether the felonious suicide of the assumed, against the law still at that time, is a bar to the present action. If the assured had taken his life whilst insane, the fact would not have constituted a defence. The act of an insane person is not, in law, his act.
That's a defence for the insurer. Yeah.
But such a death is a death within the terms of the policy unless there are special conditions excluding it. But suicide, when sane, is by English law a felony. And it was the level of fault rather than the act itself which was to be decisive. There needed to be a question, an inquiry into whether or not there was fault.
So you're saying that. It doesn't say that here. You're saying that there has to be a level of inquiry as to the level of fault. That's not a quotation of any that appears here.
No, in Beresford there was needed to be, the question is whether or not he was sane or insane.
I'm sorry. Can you just help on one thing on the on Beresford? The quote at 74. Is that from the Court of Appeal or from the House of Lords?
House of Lords.
Because it goes on to say at 75, an appeal to the House of Lords was dismissed.
Yes, sorry, you're
So this is
quite
the
right.
Court of Appeal that's been quoted, and then goes on to say Lord Atkin confined his reasoning to the situation of an intentional suicide by a man of sound mind. So it looks like
Yes, it
that
didn't
quote is from
overturn,
people.
yes.
Yes, that's the Court of Appeal.
I don't think we have Beresford in either the House of Lords or the Supreme Court in our. Sorry, the House of Lords or the Court of Appeal in our
Your
authorities.
Lordship is right. We have got a copy of it, or I think we can give copies of both of those over.
Thank you, that would be useful.
I think it's helpful to consider the judgment further. So that you looked at the US case of Forest and Kurtz, which is in the bundle at tab 39, which is page 1035 of the electronic bundle. I won't go there because Chief Justice Spiegelman deals with the point I want to make, and I'll run out of time if I go to each authority. But it is worth reading from paragraph 77. One United States case is in point. In Borshevitz and Kurtz, an outpatient at a mental health centre killed 2 people. She was charged with murder and entered a plea of guilty but mentally ill. The court entered a finding of guilty but mentally ill and sentenced her into incarceration. In some states, such a finding is an alternative to insanity, with the consequence that incarceration is in a treatment facility. She brought an action against a psychiatrist and the mental hospital, alleging that their negligence caused her mental condition to deteriorate until she ultimately became insane and committed the killings. The trial judge dismissed the complaint. On appeal, the judgment of the trial judge was reversed, and the case was remanded for further proceedings. The court said, the plaintiff has alleged that she was insane, and we must accept this allegation as true. An insane person is not held to be responsible for his acts. Plaintiff is allowed an opportunity to rebut the prima facie case and prove that she was clearly insane. In other words, she should be allowed to demonstrate that she did not commit an intentional act, and thus was not guilty of the crime. This is a question of fact. Whether she can maintain the burden of proof is not our concern at this juncture. The defendants claim that even if Luanda is not criminally responsible for her actions, she has still committed an immoral or a wrongful act. We reject this argument. Society cannot hold people who are insane to the same moral standards as people who are sane. Additionally, the term wrongful must take on a different meaning in the context of an allegation of insanity. And that's where Chief Justice Spiegelman leaves it. But I think it's important to just bring the court a little further on in time from that. There was he had referred previously.
Sorry, just before we leave Borusevitz, just for my note, this is a decision of a state court in Illinois, is that right?
Yes.
It's not a federal court.
No, this was the Borshevitz and Kurtz. I'll just take it to it.
Well, I take it from you.
It's in tab 39, and it's at page 1035 of the bundle.
Yep. Sorry, you were about to take her somewhere else.
I think that there is a case that was decided by the Michigan Court of Appeal called Vingle and Berrien, which appears to go the other way, and I would just like to take you to that. And that is at tab 38, which is page 1033 of the electronic bundle. And in this case, which you can see the entire judgment of the case just in one paragraph on page 1034.
Just one moment, sorry. Yep.
So the circuit court had granted summary disposition. The plaintiffs had appealed, and the Court of Appeal had held that the person found not guilty by reason of insanity could not recover for his alleged negligent treatment as an outpatient, and the parents and sister could not recover either. On the second page, you see the opinion, the judgment given by this appellate court. The plaintiffs appeal as of right from an order of the circuit court granting defendant's motion for summary disposition. We affirm, and the reasoning, although the plaintiff, Larry J. Lingle, was found not guilty by reason of insanity in the shooting death of Robert Tollockson, the trial court did not err in granting the defendant's motion for summary disposition. A plaintiff cannot benefit from a cause of action founded upon an immoral or illegal act, and they cite in support of that case of Glazier and Lee. And accordingly, Larry Lingle's negligence claim arising out of his treatment as an outpatient was barred. Lingle, the authority for that proposition, Glazier and Lee, was in fact a case where the claimant had been convicted of voluntary manslaughter, not acquitted on grounds of insanity. And this case of Lingle was subsequently reviewed by the Supreme Court in the case, the Supreme Court of Georgia in 2011, so post-dating Hunter, in the case of O'Brien and Bruscato. And that case is at tab 42 of your Bible, at paragraph, electronic page number 1210. This was a decision of the Supreme Court of Georgia regarding a professional negligence claim against a psychiatrist after Mr. Bruscato killed his mother as a result of deficient treatment. Mr. Bruscato was found to be incompetent to stand trial and was committed to hospital. And the judgment of the court can be seen, or the important part perhaps, pages 1213. Bottom of 1213. After reviewing this case, we believe that the public policy issues were correctly examined and determined by the Court of Appeal, and we adopt the Court of Appeal's analysis. In most circumstances, one may not profit from his own act of wrongdoing. Therefore, when one knowingly commits a wrongful act, he cannot use this act for personal gain. There may be situations, however, when an individual's psychiatric disorder prevents him from exercising a reasonable degree of care to prevent himself from taking improper and illegal actions. And the court went on to state, just a little further down the page, the next paragraph, that there was still a jury issue. In this case, a question of fact.
So sorry, just before, in case I forget it, we've been referred to some cases which you'll probably be dealing with later about insanity as a defence to tort claim. Are there any English and Welsh authorities on insanity as relevant to contributory negligence? Clearly, in Georgia, there had been a case on that point, which is what is referred to by the justice here.
Well, there is discussion about whether matters can be left to the realms of contributory negligence otherwise, but I need to make myself a note to come back to you on that. But I don't think of a specific case
Well,
on that point.
if there was analogies with these different areas of tort are interesting, that they may in the end be inconclusive. So it would be just useful to know that you or Mr. Goodcamp has indeed any of the counsel involved, sorry, in the wrong place, has looked at those questions if there isn't anything that's useful to know in itself.
Yes. And the question that your Lordship is asking about is the application of the illegality defence to tort? And
I was simply asking.
or where the offence is tort?
There's a broader question. That wasn't what I was asking about. The question I was asking about here is whether anyone has opined on the fact that if you haven't taken reasonable care for your own safety, which is a classic test of contributory negligence, whether a different test is to be applied, where the reason you haven't done so is mental illness. I mean, as it happens, I was involved in a case last year about drunkenness, but that's different because it's self-induced.
So there is an issue of fact about that in our case, but even without the issue of fact, yes, it would be our submission that those are matters which need to be left until trial to determine.
No, I'm not asked about the facts of this case, Ms. Blythe. I'm asked about the principle. Because this is all about, effectively, whether someone in the claimant's position should be treated for the purpose of tort law as responsible for their own actions. And that can come up in a number of different contexts. One is the one we have here, where they've suffered the loss for which they are claiming as a result of acts for which they are not, from one point of view, responsible. But it may also come up in the question of whether they can raise lack of responsibility as a defence when they're sued by someone else.
Yes.
And it can also come up in the context of contributory negligence. And speaking for myself, maybe not for my ladies, it would be useful to know what tort law's answer is about all three of those, if there is one. The question about whether it could be used as a defence is one which we were addressed about yesterday, and that's we were taken to Dunwich in particular.
Yes, and there's consideration of that by Lord Sumption in Les Laboratoires.
Well, maybe I didn't notice that, but in Dunwich, I was looking at the judgment of Lord Justice Voss, and but sorry, I didn't mean to make a big meal about this. I've just wanted to be confident that someone has done research into what the position is about contributory negligence. Thank you.
In this case, I don't think that the point of this case is that there was, if you like, a sort of the court could not come to a summary view that Mr. Bruscato, who had killed his mother as a result of the deficient treatment, couldn't come to a view as to whether or not his claim was to be struck out, as it were, for illegality, because he was still incompetent to stand trial. And so the answer was not known as to the question of whether or not he had been, whether or not he would be convicted of diminished responsibility, manslaughter, or acquitted on the grounds of being not guilty by reason of insanity or the equivalent. So that, in effect, at page 1214 of the bundle, in this case, a question of fact remains about whether he knowingly committed a wrongful act. There's no question that he killed his mother, that much has been admitted. There is a considerable question, however, regarding Bruscato's sanity and competency at the time the wrongful act was committed. At present, although he has been indicted, he has not been tried for the murder of his mother. No jury has found him guilty of the crime. And therefore, as the Court of Appeals found, because no court has entered judgment finding him legally responsible for his mother's murder, and because the issue of his mental competence at the time of the crime has been disputed, a jury issue exists as to whether he had the requisite capacity to commit murder. As a result, at this moment in time, it cannot be said that should Bruscato's claim against O'Brien be successful, he might profit from knowingly committing a wrongful act. Put at the heart of the illegality defence, knowingly committing a wrongful act. Concomitantly then, O'Brien's motion for summary judgment based on such an argument cannot succeed. It's interesting to note that in this case, Lingle, the Supreme Court of Georgia's authority, very short paragraph which I took to was noted, and in a footnote at page 1215 of the bundle, you can see at footnote 3, the court concluded that although O'Brien cites Lingle and Berrien County, which superficially appears to support his position, the defendant cited no support of his position. The case is only a short per curiam decision which contains no reasoning and lacks any persuasive authority.
Could I just ask one other sort of technical question about this? This clearly helps you, of course, but it's quite short. If they say we generally adopt the Court of Appeal's analysis, are we to believe that the Court of Appeal produced a more elaborate and fully reasoned judgment? If so, wouldn't be no harm in seeing it. If it really says the same as the Supreme Court, then obviously we're not interested. But again, someone ought to look if they haven't already.
I think in a way, and one of the reasons I go through this by reference to Chief Justice Spiegelman's judgment is that there are so many authorities where it is assumed or said in passing that there needs to be culpability or wrongfulness.
There are very few, as my lady pointed out, very few on these sorts of facts.
Very few on these sorts of facts.
And the only, apart from Hunter,
Yes.
And it looks like Riscasso, although the facts weren't established, but the point of principle was considered.
Yes.
Those are really the only ones, which is why it's quite worth looking in depth at them in case they shed any useful light. Maybe they don't. But
Yes, I did try to find the decision, but I'm not sure where I got to. I'll go back to research and stuff. But the point is taken. I think that it's right that it hasn't been applied, but there are very few cases where insanity was the defence. That is right, and perhaps inevitable. But the principle has been discussed on repeated occasions, and it's that which we're seeking to demonstrate to the court. And save for the case of Lingle, the same conclusions are withdrawn again and again, that where somebody is neither legally nor morally responsible for their acts, it's inappropriate to apply an illegality defence. And just to come back to Hunter briefly, and to, I can do this quickly so we can move on, but for your note, Scheller JA, who was in the majority with Sandhurst JA, also reviewed ex-terpi authorities, and he concluded that they provided no support for the application of the illegality defence in cases of insanity. And he comes to that conclusion at it's tab 41, Hunter, and it's page 200. It's paragraph 293, which is at page 1188 of the bundle. And this is what Scheller says. The theme, through the cases I have referred to, is that where compensatory damages are claimed for the consequences of a criminal act, where compensatory damages claimed for the consequences of a criminal act are refused, this is because the act was indeed criminal and the plaintiff was sane when committing it. He does go on to dismiss the claim in Hunter, but he does so on the basis that identification of the nature of the harm pointed as a matter of common sense against allowing the claim. And that's at paragraph 300 of page 1198. And Justice Santo also...
So you're saying his after this rather lengthy judgment, it all comes down to his application of common sense.
And to he looks at breach of duty and he looks at causation, but in the end it's the nature of the harm, it's the losses for non-physical injuries. And Justice Santo also strikes out, or not strike out, there's been a trial, but also dismisses the claim on the basis of principles which are not related to the ex-causa, but related to normative causation and or the nature of the losses. And he is explicit at paragraph 315, which is in the authorities bundle at page 1194.
So, sorry, which paragraph did you say?
315. Santa J. He says, while here the respondent was by reason of insanity judged incapable of acting with the necessary intent, his act of homicide was an unlawful act. I'll come back to that when we consider the nature of acquittal for not guilty by reason of insanity. But his act of homicide was an unlawful act, hardly to be described as constituting reasonable action. And then he says, without in any way relying on the exterpa causa maxim, I ultimately conclude that it would be unjust for the common law to allow the respondent a remedy for the non-physical injuries he has suffered in these circumstances. I here differ respectfully from Spiegelman CJ's conclusion to the contrary at 78. And then he clarifies, I do not base my conclusion on any moral culpability on the part of the respondent. Rather, I base it on what I conceive to be legal policy, ultimately based on community values, which would consider just in such a case. And at paragraph 380. Page 1207. Goes on to say, under a subtitle, relevance of the unlawful conduct or exterpa causa, I agree with the observations of both Spiegelman CJ and Scheller JA, who have undertaken the review of the authorities, insofar as they deny application of the exterpa maxim as a defence to a civil action, or as automatically breaking the chain of causation, where there is no crime, nor any rational and voluntary act, nor any moral culpability, by reason of the respondent's insanity at the time that he killed Miss Lord. That said, I consider that the residual unlawfulness of the respondent's act of homicide is a factor that may properly be taken into account when considering normative aspects of causation. And he goes on to look at causation as it was. Returning really to the point I was making initially about Gray, it is right that Lord Hockman noted the different outcome to the case of Hunter and Presland. But in my submission, when read carefully of those judgments, it's a stretch to say that the basis of their dismissing the claim was related to the defence of illegality.
Yes, but if one has to read on, I think. I mean, I understand the point you make about the limits of this for the reasons you've identified, but I don't think we can ignore the reasoning that underlies it. So, for example, if you go on to look at the paragraphs that deal with what a plea of insanity actually means.
Yes.
So, although it's headed causation, if one looks, for example, at paragraph 382 and 383, because there he's really addressing what might be said to be the heart of the matter here, which is how do you deal with the responsibility of somebody in negligence in a case in which they have been acquitted of a criminal responsibility on grounds of insanity.
And that would be important. They certainly refer to that being a residually unlawful act. That would be important in going on to look at the effect of the acquittal. But I think it's quite, and if one looks at paragraph 382, the effect of a successful plea of insanity is that the act of homicide, while remaining unlawful in view, is shorn of both criminality and in an enlightened society of moral opprobrium as well.
Yes, but he's thinking that moral culpability isn't the ultimate test, as he said in an earlier passage you've shown us.
Before leaving Gray, then.
Sorry,
Yes.
If you're going to leave Gray, or indeed, strictly speaking, Hunter, I think I did flag up, I'd like to hear what you had to say about the example given by Justice of Appeal Scheller at paragraph 300 of the judgment, referred to by Lord Hoffman,
Yes.
of the case where the defendant is the is in fact the victim.
So, I was just looking up because we did have a
Defendant in the negligence action.
Yes, I'm sorry, the defendant in the negligence action is the victim.
The estate of the deceased victim.
Yes. Or it needn't necessarily be a case of death, because it could be a case of life-changing injuries. But the person.
Yes, what I'm reaching for is it's skeleton in the court below, because I dealt with that on there, and I may have done it more elegantly than I will if I think off the top of my head now. But the point is that these sad ironies unfortunately exist in a number of cases where the deceased is also the tortfeasor, and that can occur in circumstances where there was fault on both sides of the
Yes.
claimant as well as the
Well, maybe, but it's sometimes important to test the principle by reference to particularly stark examples. So I think to say sometimes the defendant may be at fault, the victim may be at fault, doesn't really.
But the doctor in that situation would have been acting. The purpose of his engagement, if you like, the very thing that he was engaged to do, would have been to have been taking care of
Yes.
the claimant's mental health. And in breaching that, an action in tort would arise against him. And if he was injured as a part of the consequence of his failure to treat the patients well, that introduces an element of irony, and one feels sorry for the individuals concerned there. But that doesn't prevent, as a matter of principle, the fact that he was in breach of his duty of care to the claimant in order to prevent just that.
No, I see. I think that's what your answer has to be, and I accept that. I'm not suggesting it's a knockout point, but it is a concerning point, because one of the considerations here is ultimately talking about public policy. And the element in public policy, as is recognised in all the cases, is public confidence,
Yes.
which, although that makes it sound very grand, is what the ordinary, reasonably intelligent and sympathetic citizen would regard as a fair outcome. And clearly what lies behind both Justice of Appeal Scheller's example and Lord Hoffman's picking up of it is that it might be thought that people would think that can't be right. He's the victim. He's died or been permanently damaged, and now he's being sued by the person who did it. Intellectually, I see your answer, but I think we're going to have to consider whether that is an acceptable outcome.
And I will, of course, go on to look at public policy, including the public conscience.
Yes.
This sticks in the craw point. Which
Yes. Well, if you're going to come back to it later, but I thought since we were talking about Hunter, which is where this example is given, it was worth dealing with it now.
I mean, I think the two broad points I'd make in relation to that is, firstly, one can be surprised by public opinion and has to exercise some caution when
Yes, of course.
trying to
Yes.
But if one wanted to intelligently speculate on what the public might think about our case, about Mr. Lewis-Ranwell's, you have some evidence to assist you in looking at that. That the jury, after 2 weeks of looking at, including the photographs of those very harrowing events, acquitted him of moral appropriate. And they went further and said, what about the care? And that gives some indication, we say, of how the public, you don't need to take a poll, you've got 12 random...
Well, in a sense, we stand for the public, I'm afraid. We can't do a poll. It's our job to reflect what on our understanding public confidence would be, and we see judges doing that. So, but speaking for myself, I have no difficulty at all in understanding how harrowing this is from the point of view of Mr. Lewis-Ranwell, who was mentally seriously ill,
Yes.
and in many senses not responsible for his actions. And I take that on board fully. But the fact remains that in not necessarily his situation, we can't distinguish between different particular facts and different situations. There must be a principle here that the victim is being made liable for damages to the person who has done him this terrible physical injury. There may not be that much more to say, but it's obviously a point we want to consider, and I just wanted to know what you said about it.
It's undoubtedly a starker point in Hunter than it is in this case. When I was referring to harrowing, I meant to talk about the death of the three gentlemen rather than...
Yes, no, quite.
But yes,
Well,
perhaps I come back to that in public policy. I understand it. I understand the point made in Hunter, and my point is that it can't affect the point of principle. There are terrible ironies in a number.
No, I see that.
But what does that?
Indeed, one way you could put it is that they are both victims. I mean, the deceased are victims, but so also, if your case is right, is Mr. Lewis-Ranwell, a victim of not being properly treated. So I do get it, but it still leaves a very uncomfortable feeling.
And the point about this case is that what led to the killings was ejecting him out onto the street on 2 occasions, despite all of the warnings. So that the causation point, the very thing point,
I don't want to stop you, but that doesn't really address the point of principle. I fully understand that if the case as pleaded is established, he is a victim too.
But if when talking about how the public would respond to the situation, it depends how informed the public are.
Yes.
And it depends whether they know about the sequence of events.
But I don't think you're suggesting that each case, it should depend on exactly what the nature of the breach is. That would be a very unsatisfactory situation. We've got to deal with it generically on the basis there has been a breach by the defendant, who in an extreme case might actually be the victim. That's the shallow example, but in this case it's somebody else. Sorry, there has been a breach by the defendant. And so that the claimant is themselves the victim of a wrong. Quite understand that. But we can't go into just how bad the breach was or what the particular facts were. There's got to be a principle that applies to any breach, wasn't there?
I think that there is, with respect, there is some principle about the question of what the breach, the nature of the breach in relation to the act that was taking place. So what we say is that the very thing that the mental health practitioners were engaged to do was to divert the claimant, but was to.
But that will always be the case, otherwise there won't be a breach. Otherwise there won't be a breach or causation.
But the causation follows from that, in that the very thing they were engaged to do was to prevent this happening.
Yes, but I'm assuming you win on causation. This trace doesn't arise unless you've got causation. So, anyway, thank you.
I wanted just to emphasise before leaving, Greg,
Yes.
that the criminality of the conviction for diminished responsibility mandate was, of course, central to the reasoning of all of the judges. But also so was, in my submission, the question of culpability. And looking at Lord Hoffman's reasoning, which is in the authorities bundle at 488 to 499. Paragraph 44. Just at the very bottom of that paragraph, as the Hunter and area precedent shows, it may reflect, which may reflect more than one facet of public policy, but it is sufficient in the present case to say that the case against compensating Mr. Gray for his loss of liberty is based upon the inconsistency of requiring someone to be compensated for a sentence imposed because of his own personal responsibility for a criminal act. If I just take you briefly to the judgment of Lord Roger and at page 498 of the bundle. And you notice that you notice the conviction and the detention, and then he said the civil courts must proceed on the basis that even though the claimant's responsibility for killing Mr. Boltwood was diminished by his post-traumatic stress disorder, he nevertheless knew what he was doing when he killed him, and he was responsible for what he did. Similarly, it must be assumed that the disposals adopted by the criminal court were appropriate in all of the circumstances, including the circumstances that he was suffering from PTSD. Whilst it is correct to say that a hospital order, even with a restriction, is not regarded as a punishment, this does not mean that the judge was treating the claimant as not being to blame for what he did. On the contrary, even where there is culpability, a hospital order with a restriction order may well be the appropriate way to deal with dangerousness and disordered persons. We must therefore proceed on the basis that Rafferty J correctly considered the orders which he made were necessary for the protection of the public from serious harm.
Maybe that there's not a great deal of weight that one can place on it, but it's interesting that Roger at least is placing emphasis on knowledge of what he was doing when he killed him, as opposed to knowledge that it was wrong. Responsibility for what he did, well, responsibility, yes, but I don't know whether that has the overlay of criminal responsibility.
If we turn to Henderson, which is at tab 34 of your bundle, the claimant had also been convicted here of diminished responsibility manslaughter, as you know, and the effect of the claimant's argument was that her situation should be considered in the same way as an insanity case, avoiding the illegality defence. It was assumed by virtue of the reasoning included. And the Supreme Court rejected that argument and emphasised instead the boundary between the diminished responsibility cases and that insanity case, as was was drawn in Clunis. You can see this, Lord Ranwell giving the judgment of the court at paragraph 105, which is page 967 of the bundle. In this paragraph, he reiterates the references both to insanity and to the knowledge of wrongdoing. He's interpreting Gray. Okay, paragraph 105. Can I help? Have you got
No, I was just looking something up.
As explained above, the key consideration as far as the majority in Gray were concerned was that the claimant had been found to be criminally responsible for his acts. That he had been convicted of manslaughter on the grounds of diminished responsibility meant that the responsibility for his criminal acts was diminished, but it was not removed. It was not an insanity case. And so, as Belden pointed out in Clunis, he must be taken to have known what he was doing and that it was wrong.
Can I ask you about something in paragraph 108?
Yes, it's coming down.
Ah, right. But this is just, as it were, looking at it from the other end of the telescope. Lord Hamlin there was talking about the possibility of inconsistency if the degree of personal responsibility is a matter for the trial judge to determine in the civil claim, and there's a risk of inconsistent decisions. On that footing, it might be said that in this case, it wouldn't be open to the defendants to defend the claim on the footing that the claimant bore some responsibility for his actions. Would you say it's, I mean, would you say it isn't open to them to do that?
The reasoning is so strong. And it's in the light of that what is relevant is the distinction in the criminal court, and that is to be paid proper heed. And if you disregard that, minimise that, and try to set up a different test in the civil court, you increase inconsistency, and that falls foul of.
Yes, but my point is that looking at it on its face, paragraph 108 seems to suggest that once there's a determination of responsibility in a criminal case, it's not open to a judge in a civil claim to revisit the issue by looking at the responsibility of the claimant.
Yes, I think that
and
right.
defence.
I don't, to be fair, think that the defendants are seeking to attribute, to go behind the conviction. What they're seeking to do is to say that, as I understand it, the nature of a special verdict is something which engages the public interest, and therefore we can fit under the quasi-criminal. But I don't think they're suggesting, maybe wrong, that the...
No, but it would be a point for you to argue that in this case, in the claim, if it's allowed to go forward, that it's not open to the defence to say that the claimant bore any responsibility for what he did, because that could give rise to an inconsistency with what the criminal court
I do say that.
Yeah.
Thank you. I think just for your note, I'm not making very quick progress on time, but paragraph 112.
I think that's our fault rather than yours. So.
It was also noted in Henderson that it wasn't only the plea of guilty to diminished responsibility, but it was the basis of that plea of guilty was on the evidence of the expert psychiatrists who had agreed that the appellant knew what she was doing was morally and legally wrong when she inflicted the stab wounds on her mother. And I just, that's paragraph 112, just draw attention to that, unless there's any suggestion that one way or the other in a trial for murder can be based on anything other than evidence. That also is in contrast, of course, to the evidence and the verdict in this case. And the court also considers, you've seen, the submissions by the claimant that because the hospital order was not a punitive sentence of the court, in circumstances where a punitive sentence could have been open to the judge, then there was no turpitude. And those submissions were rejected at paragraph 109, I think you have it open there. Nor does the fact that there may be no penal element in the sentence alter matters. As Lord Roger observed at paragraph 78 of Gray, even if the sentence is not regarded as being a punishment, this does not mean that the judge was treating the claimant as not being to blame for what he did. A conviction for manslaughter by diminished responsibility still involves blame. The defendant would otherwise be convicted of murder and some responsibility for unlawful killing necessarily remains. Moreover, the fact of criminal conviction for manslaughter is in itself punitive. And so, at risk of repeating myself, on the basis of a plain and untortured reading of Clunis, Gray and Henderson and the reasoning in those cases, the defence should not apply in this case. That was the understanding of Mr. Justice Johnson in Traylor and Kenton Medway, the first insanity case to come before courts in this country. And it was also the understanding of Mr. Justice Garnham in this case. And in my submission, the judge has followed this clear boundary and reasoning, and had he done otherwise, his judgment would have been contrary to the reasoning in those cases. And it's more than just an application of a corollary. It's conceptually sound to interpret the reasoning and the authorities as applying the other way round to insanity cases. And the reason for that is that the illegality defence cannot arise in cases where a claimant has been acquitted on grounds of insanity, because there is no illegality, because he has proved in the court of law that he has no moral culpability. No punitive sentence has been imposed. And the illegality defence demands at least illegality or moral culpability and or punishment. And it would be incoherent for the civil court to ignore the finding of the criminal court, and not a matter for them, as Lewis says, to go behind that. And it would be incoherent to find legal or moral culpability and impose a punishment in the civil law.
You wouldn't be imposing a punishment in the civil law.
Well, imposing a draconian defence so that he is in effect, if I put it this way, outlawed, cannot come before the court with his means that it has the effect of a punishment. Is my suspicion. So I think I spoke across the board.
I think you've been denied compensation for a civil wrong.
And denied vindication of his rights to mental health provision in the police station. The civil and criminal law march together in this respect, and it's not just out of a rigid application of rules or applying the corollary of what was said in one case to another, but there are important qualitative differences which between the diminished responsibility manslaughter and an insanity defence. And those differences I'll come on to in my next submission, but they are the same really as those qualitative differences which go to the heart of the illegality defence.
You will be coming at some point, will you, to the suggestion that civil law and criminal law don't march together, in that insanity is not a defence to a claim for negligence?
Yes, I will. I'll come on to consider.
Well, that's fine. No, as long as you're coming back to it.
I can answer that briefly. The question is, what is the criminal? Well, perhaps I'd better come to that.
Should come to it later. No, I just wanted to check that you were going to come back to it. That's
Yes,
fine.
I am. it may be factually difficult to fathom the state of mind of somebody and to decide whether or not it was an insanity case or diminished responsibility, and that's the but the distinction is not conceptually difficult to understand. And it's well within the normal realm of criminal law to consider the state of mind of a defendant. And my submission is that once it's established, it is binary. He's either culpable, responsible, or he is not. Of course, there are levels of blameworthiness where you are responsible, and diminished responsibility manslaughter caters for that. But importantly, as we've already seen in part, and come to see later in Les Laboratoires and Apotex, this distinction, the same distinction between culpability and non-culpability, is maintained in civil cases regarding the illegality defence. It may require an inquiry into the claimant's state of mind, but it isn't a question of degree. The conclusion will be a finding that the claimant was aware of the illegality, or was wrong, culpable, knowingly wrong, or he was not. And I derive authority for that proposition from Lord Sumption in Les Laboratoires at paragraph 29. I won't take you to it now because, if I may, I'll take you next to the question of the legal status of the claimant in this case following his acquittal, and to the criminal law relating to that. The defendant's case, or the defendants aver that the claimant's act were quasi-criminal on the basis that a finding of not guilty by reason of insanity is not the same as a full acquittal. And or, secondly, on the basis that the acts engage the public interest in that they lead to a special verdict with a hospital order and restriction, and that those are themselves sufficient to enliven the defence. Deal first of all with the question of whether finding of not guilty is a full acquittal. The judge was right, and I put this in my skeleton at paragraph 16, and as I said at the beginning, expressing an entirely orthodox opinion in line with previous authorities when he says at paragraph 132 of his judgment, which is in the core bundle of page 163, the claimant is not guilty of a crime, and there is a fundamental difference being guilty of diminished responsibility manslaughter and not guilty by reason of insanity. In the former case, responsibility is diminished but not eliminated. In the latter case, it is eliminated, because insanity means that the defendant does not know what he was doing was wrong, and that knowledge is essential to a fixed responsibility. And it's helpful to start by looking at the offence of murder. Mr. Warnock also took this yesterday, but murder is committed where a person of sound mind and discretion unlawfully kills a person intending to kill or cause grievous bodily harm. It's a section from Article dealing with that is in your bundle at tab 50. But murder is committed where a person of sound mind and discretion unlawfully kills a person intending to kill or cause dubiation. Given the emphasis on maintaining the coherence of the law, in my submission, Mr. Justice Garnham was right to start his consideration of the law by looking at the relevant statutes. Obviously, the court was defined by the terms of any statute. And he starts, diminished responsibility manslaughter is provided for by Section 2 of the Homicide Act. And that is at tab 2, Authorities Bundle, page 7. And it is clear from Section 2 of the Homicide Act that a defendant who would otherwise be convicted of murder can involve this partial defence, as long as they can establish that there is suffering from an abnormality of mental function arising from a recognised medical condition which substantially impaired their ability to understand the nature of the conduct or form a rational judgment or exercise self-control, and that this caused or significantly contributed to the killing. By definition, the defendant remains guilty of manslaughter, a serious criminal offence. And this, therefore, runs straight into the illegality bar, and those representing Mrs. Henderson clearly had an uphill struggle which they lost to try to establish otherwise, but it runs straight into the illegality bar because of the inconsistency which would be caused by allowing a claim based on a serious criminal offence for which the claimant was responsible. But by contrast, Section 2 of the Trial of Lunatics Act 1883, as amended, provides for what occurs in the situation where there is a defence of insanity. And that's at page 3 of the, tab 3 of the bundle, which is page 5. And section 2.1, where in any indictment, any act or omission is charged against any person as an offence, and it is given in evidence on the trial of such a person for that offence that he was insane so as not to be responsible, according to law, for his actions at the time when the act was done or omission made, then if it appears to the jury before whom such a person is tried that he did the act or made the omission charged, but was insane as aforesaid at the time when he did the act, the jury shall return a special verdict that the accused is not guilty by reason of insanity. Thus, just at its simplest, Parliament dictates that a defendant who is insane at the time of the offence, of the alleged offence, is neither responsible nor guilty of the illegal act charged. And inherent in that statutory provision is the finding of insanity. And the established test for that, of course, is the McNaughton test, and that was established well before the Trial of Lunatics Act. And the jury in this case acquitted Mr. Lewis-Ranwell, as you know, on the second claim that he did not know what he was doing was wrong. But on the basis of statute alone, there is no criminal liability. And the defendant tries to chip away at that sentence. They try to chip away at it. They put emphasis on the words special verdict. The previous court had relied on a non-subheading to the Act, which referred to the original Act, whereas we also pointed out yesterday, it used to be that a defendant with an insanity plea was found to be guilty but insane. But as the judge noted at paragraph 132 of his judgment, I don't think we turn it up, section 2.1 of the 1883 Act was amended. And it was amended to make it clear in 1964 that insanity eliminates criminal responsibility. Section 1 of the Criminal Procedure Insanity Act, which is at tab 3 of your bundle, specifically removed all references to guilt and criminality and replaced the words guilty but insane with the verdict of not guilty by reason of insanity. There isn't any room for doubt as to the express intention of Parliament. There is a distinction. There was a distinction, and if you establish the insanity defence, you are not guilty. The fact that it's still described as a special verdict in order to enable there to be a distinction when looking at public protection and so on and so forth doesn't alter that. It doesn't detract from the substantive fact that the claimant was not responsible because he did not know what he was doing was wrong. And in the law of this country, he is not guilty as a consequence of that. He's acquitted of criminal responsibility, and by virtue of the nature of his defence, of moral responsibility as well.
So you would draw no distinction between somebody who is acquitted in normal circumstances and the position of the claimant in this case. So somebody, for example, who's acquitted because they didn't do the act, or somebody who's acquitted because of murder on grounds of self-defence, and the position of the claimant in this case, who, where there was what's called the special verdict. You say they are, for all purposes, identical.
My lady, for the purposes of criminal liability or for a policy of how this country treats homicide, they're not guilty. That is eliminated. That's not to say that the same things happen. What's important to go back and look what happened. He killed, and he killed as a result of being insane. But that doesn't attach criminal responsibility to him. It may very well be important to look at that when considering how to manage risks in the future, or to manage his mental health in the future. And it may very well be important to distinguish between the two types of acquittal so that you can ensure that claimants who are insane are not deprived of their ability to also put forward, defendants who are insane are not deprived of their ability to also put forward a defence to a charge on the basis that these acts could never have amounted to a criminal offence. And that's a reference to the AG, the Attorney General Reference 3 case. It may be important in the same way perhaps that a narrative verdict can be important in a coroner's court to tell the story of what happened. That's going to be relevant for many aspects of telling it as it is, how he can be looked after.
But we don't have narrative verdicts in criminal courts.
No, that may I hadn't thought of it like that, but in a way perhaps that's the closest. The special verdict is not guilty by reason of insanity. It gives an explanation, but no, we don't. But it has a purpose, it has a function, but that doesn't alter the central point of whether the criminal law sees him as responsible and liable.
The difference surely is that in a case of an ordinary acquittal, there is no crime for which this person is responsible. There may be a crime for which somebody else is responsible, I suppose, if there's a defensive alibi. But in some cases there may not actually be a criminal act, whereas here the special verdict doesn't deprive the act of its quality of being a criminal act. It just absolves this particular defendant from responsibility for doing it.
No, should I think I'm careful not to use the word a crime must involve, in my description, all of the elements of the crime and an absence of a defence.
Rather than crime, let's say an unlawful act,
or even an act of battery, assault, of killing, a homicide. There has been those things. There has been those things.
That's the point.
Sorry, I didn't hear what you said. There has been no.
There has been those things. There has been a battery, and there has been killing, but there has not been a crime.
Yes.
And it's submitted that, well, it was submitted in the court below by my learned friends that you couldn't put a cigarette paper between the relevant facts of Mrs. Henderson's case and that of Mr. Lewis-Ranwell. This perhaps illustrates the point. And it's one thing for us to say that in the civil courts, we don't, but the criminal law and the defendants within it take that distinction very seriously. And that is reflected in the substantive law, statutes we've looked at, in the procedure undertaken in the Crown Court to determine which of those categories one falls into, guilty or not guilty, and the outcome. And the insanity defence, it has a very high procedural and evidential bar for the claimant to establish their insanity. So 4 things about that. The burden of proof of insanity rests on the defendant to the criminal trial. Proof of insanity must be based on the expert evidence of at least 2 psychiatrists, Section 1.1 of the Criminal Procedure Insanity Act. Neither the prosecution nor the court can accept a plea of insanity. The involvement of public opinion is required. The involvement of a jury is required. Pursuant to Section 2 of the Trial Agreement Act. And in this case, which is just one example of many, there was a 2-week publicly funded jury trial involving extensive lay and expert evidence from 3 psychiatrists in order to determine this precise distinction. It's a distinction that the criminal law pays significant heed to, and it was a unanimous verdict.
Sorry, I hadn't picked up. Did the Crown seek to resist?
They tested the evidence.
They tested the evidence.
They
didn't call evidence of their own.
There were 3 psychiatrists called, and
Yes, but was any of them called by the Crown?
yes, I think that the third, I think one of the psychiatrists was called by the Crown. I'll just check that. I haven't reread the transcript in a while, but I will check that. But they certainly tested all of the evidence, and you can see in the excerpts of this summing up this is Justice May's summary of the evidence of each of those psychiatrists. There was an inquiry into precisely that distinction, and it was carefully done. And the defendant's next submission really is to the effect that, well, okay, so there isn't a criminal responsibility, but there is. This was a case where both the actus reus and the mens rea of the offence of murder would otherwise have been proved. The verdict itself makes no particular comment on mens rea in this case, but I understand the point which is being made. We looked yesterday at the Attorney General reference number 3, 1998. That's at tab 21, page 442. I think, ladies and gentlemen, you have my point here, but I just to just for your notice that it isn't lost. It's clear from that the proof of mens rea in an insanity case is effectively superfluous. So page 449, paragraph D. Once it's decided that the defendant was insane, the mens rea becomes irrelevant. The Court of Appeal took the view in this case that in a criminal court, the prosecution did not need to establish mens rea in order to establish that the act was done, but that they should establish that the defendant had brought about a set of circumstances which, absent the defence of insanity, would contravene the criminal law. That is correct. We talked about that yesterday, the example of the swimming pool and so on. But the reason for this given wasn't to attribute blame by a back door to the defendant, because it doesn't say anything as to that. The reason for this was to ensure that the defendant would have all proper avenues of defence available to him. Insanity, of course, but also he chosen to do that, or by appeal, by showing that circumstances did not exist, even independent of the question of insanity. And so it made sense to have that distinction. And the other reason for the need for the special verdict, as I alluded to earlier, was for the purposes of public protection. And at that time, the court had a mandatory special verdict. Following a special verdict, there was a mandatory hospital order. Page 451 deals with that. And it has rightly been pointed out in the case of Lope, which you also taken to yesterday, it's tab 31, that although it's not necessary for the prosecution to establish both the actus reus and the mens rea ingredients for murder in order to achieve the special verdict, it doesn't, if they do establish, or if it could be established that there was an actus reus and a mens rea for murder, that does not negate the insanity defence. All the mens rea in a charge of murder would say, in those circumstances, is that there was an intention to kill. It goes to the intentionality of the act, or GBH. And there's no question but that an insane person can form an intent, but the issue was whether it was driven by a delusional belief to the point where he was insane. Or reason and responsibility. And the defence of insanity, as Lord Justice Owen says in Lope, this is at page 836 of the authorities bundle, paragraph A, the defence of insanity rests on a broader basis than mere absence of mens rea. The fact that the acquittal was under the second limb of McNaughton rather than the first doesn't import culpability, doesn't import responsibility, and doesn't comment on those matters which are, or does the opposite, it eradicates those matters which we say are necessary to found the illegality defence. The defendants submit next that Mr. Lewis-Ranwell has residual quasi-responsibility because the act remains unlawful despite the defence. My understanding is that they consider the act to be residually unlawful because there is no excuse or justification defence, other defences available to the charge of murder, such as self-defence. That unlawfulness appears to have been accepted really without any argument in Hunter and Breslin. We saw that earlier when we looked at it, on the basis that there wasn't any defence or justification. And I understand the comments yesterday from my lady that it's difficult to see the killings, the homicides, as being lawful. It's a difficult thing to grasp, but we may be at risk of semantics here. What is important is what happened and why it happened, and it doesn't alter. The word lawful or unlawful doesn't alter those matters.
Well, certainly from the victim's point of view, it might be said it does. I mean, these were, certainly you might take a different view, but these were unlawful homicides, in your cases, for which the claimant bore no responsibility in criminal law on the grounds that he was, that the insanity defence prevailed. But are you submitting that it wasn't an unlawful act?
But it doesn't. The description of it as unlawful doesn't add, if you like, to what happened. Doesn't make it criminal. Not quite sure what unlawful means in the charge of murder. In the offence of murder is committed where a person of sound mind and discretion unlawfully kills a person.
Yes, but it may have a bearing on the question of public policy and the illegality defence, and the question might be whether a claimant can rely upon his own unlawful act. in those circumstances as founding a claim, even if he is not responsible for it in the criminal courts.
I suppose that
And you know, somebody who was, for example, acquitted of murder on the ground of self-defence, the act itself then is not an unlawful act. It was there was a justification for what was done. Here, I think the jurisprudential analysis would be it's an excusatory approach to the to what happened, rather than one of justification.
may I take you to some academic, a little of the academic writing in relation to that.
But what is your position? Are you saying it's not unlawful? That's really the question before going into the academic. I'm not sure we need to. We've looked at quite a lot of it now.
Just take two briefly.
Yes.
The defendant's insanity took him outside of the realm of being able to reason or to make an excuse or to be able to act in a reasoned and judging the level of justification way. It takes him outside of that. There is no criminal act because he was insane at the time when he killed the man. And the word unlawful to me, it imports some criminality. If the word is intended to convey that he didn't have a defence of self-defence, that is true to say. He didn't have a defence of self-defence that we ever heard of. But to try to delve into that, it becomes superfluous, it becomes irrelevant, because he didn't get to the point where he could be. He was...
Certainly, so far as looking at the case of Hunter, the phrase unlawful act was used in Hunter.
It was.
And therefore that's as it were, the differentiates between the position of somebody who, as I say, who might have a defence of self-defence.
May I take to...
the position of the claimant here.
Sorry, I missed that.
Well, it may be said to be a difference between, and I'm asking you what your submission is in relation to that, as to whether you do or don't accept that this was an unlawful act.
The way that, sorry to not answer directly, the way in which one looks at lawfulness depends on the way in which the laws of the land provide what can be done. There isn't a free-floating unlawful, there isn't a free-floating law other than thou shalt not kill in the ecclesiastical law, that thou shalt not kill. Of course, everything should be done as possible to prevent irresponsible people who are irresponsible as a consequence of their mental illness from becoming a danger to society. But has there been something which contravenes the law of this country? No. So to that extent, I say, no, it wasn't unlawful. And
Even in a
using...
civil sense.
It was...
I thought you accepted it was a criminal
Yes, I accept that it's... Yes, there hasn't been a criminal offence. One can definitely say there has been a battery. But, yes. Yes, at all. So contrary to the civil law. May I take you just maybe the quick switch?
Sorry, I haven't quite. I think you're saying you started by saying that there was no concept of unlawfulness, no useful concept of unlawfulness, except something that was contrary to the criminal law, and this wasn't contrary to the criminal law for the reasons you've just been explaining. But are you accepting a revised version of that it is unlawful as a matter of civil law?
Yes. One needs to look at what is lawful through a series of lenses.
Well, clearly lawful
Criminal
can mean
law.
different things, but I just want to know what you mean by it,
Yes.
and what your position is.
Well, a battery is a tort which you can be held responsible in damages. You know, you can be held responsible to pay, but that's not based on an objective standard of care. It says nothing which goes to the mind of the person who commits it. So in tort, in the Morrison, Marsden and Dungeon Rat.
It's unlawful in that sense, but not in what you say is the relevant sense.
Yes.
Okay.
I think it is helpful to, well, in paragraph 20 of my skeleton argument, I quote from Professor Sinister, who is explaining this concept in the fundamentals of criminal law, and that is in the core bundle. The skeleton argument is at tab 9, and I was looking at paragraph 20 of that. As Professor Sinister explains in the fundamentals of criminal law textbooks diverge regarding what kinds of irresponsibility conditions count as defences at common law, but perhaps the most generally accepted examples are infancy and insanity. Defences of this kind are predicated on a denial of the defendant's moral responsibility for her acts. They recognise her inadequacy as an agent capable of moral deliberation, one able to process and apply moral reasoning to her actions. Rather than undertaking any exculpatory evaluation of the defendant's rationale for her actions, defences such as insanity and infancy take the defendant out of the realm of moral agents. It follows that, unlike justifications and excuses, these kinds of defences are context insensitive. Their availability is independent of the moral character of the defendant's action, its appropriateness and its proportionality to the occasion. Irresponsibility defences are capacity-based. As such, they contain no requirement of proportionality or reasonableness, no evaluation of the defendant with respect to her action. They do not speak to culpability assessments. They preempt them. They do not defray blame. They exempt them. I think that just on the following page, I referred to a chapter of John Gardner in his book of offences and defences, and that chapter is, just take you to the bundle, it's at tab 46, third bundle.
But just before we leave that, you're much more familiar with this than I am. But Professor Semester's phrase, unlike justifications and excuses, I think some academics use the word excuse on the other side of the line.
I think so.
Yeah. To mean more what he means, or he or she means by culpability, sorry, by exculpatory. Yeah. Thank you. I just wanted to be sure about that. You were going to take us to Professor Gardner.
To Professor Gardner at at page 112 in chapter 5, which is at tab 46, and page number 1330. It's marked up, in fact,
Yes.
She's explaining how a defence based on an excuse depends on the existence, or excuse and justification would depend on the existence of reason and the ability to comply with reason. And he says, those people, so it's about 5 lines up from the bottom, those people who cannot meet this condition do not need to bother making excuses. Such people are not responsible for their actions. They are free from blame as well as being improper targets for criminal liability, irrespective of both justification and excuse. and excuse both belong to the realm of responsible agency, and that is precisely because both depend particularly on the ability to live within reason. As some writers illustrate, it doesn't make sense to say that he has a residual unlawfulness which can affect the defence, because he has established that he didn't have the reason or the ability to reason to form such unlawfulness. Perhaps that point only takes us as far as the case in the Attorney General point which I've made, but in accordance, I said, with the law, both the criminal law and the current understanding of severe psychiatric illness in this country, the view of the jury, Mr. Lewis-Ranwell wasn't legally or morally responsible for the killings. And the defendants reached then for the fact that the claimant received the hospital order with a restriction, and aver that the killings engaged the interest of the state through the criminal justice system in that way. And for that reason, they say it makes his acts turpitudinous. My submission is that the judge correctly rejected the argument. It's in his judgment at paragraph 133, which is at page 163 of the core bundle. I didn't take you there, but he noted that the disposal in the claimant's case, hospital order with a restriction order, under section 5.2 of the Criminal Procedure Insanity Act, is not a punishment for a criminal act. It is instead a disposal made for public protection, made when an insanity defence is made out. And we've cited in support in the skeleton argument the Law Commission summary of that position in its paper 2013. It's at tab 53, but I can give you just the note for your note. It's paragraph 1.25. A person found not guilty by reason of insanity has not been convicted of any crime, and so he or she cannot be sentenced. The term disposal is therefore used to describe the ways in which the court may deal with such a person. The issue of disposal is important, but it is distinct from the question of who should be exempted from criminal liability in the first place. And I repeat, the disposal doesn't alter the nature of his acts. The fact that these are not powers to sentence or to punish, powers of disposal upon a finding of not guilty by reason of insanity, but are restricted to measures to treat and rehabilitate and protect the public, is not quite the same as it is in cases of deliberate responsibility manslaughter where such an order is given. The fact that a person has been convicted of manslaughter, the fact that they might also receive a hospital order or with a restriction as a sentence for their conviction doesn't alter the fact that the claimant was not convicted of those things, didn't commit a criminal offence, and received no criminal sentence. And it doesn't alter the fact that there is no role for public condemnation of him, and that he was neither sentenced nor punished by the court. But the same is not what can be said of a person convicted of diminished responsibility manslaughter. And we see that in Henderson, paragraph 109, which I've taken you to already, I think, but it's authorities bundle, page 967. Nor does the fact that there may be no penal element to the sentence imposed by the criminal court on Mrs. Henderson alter matters. As Lord Roger observed at Gray, said paragraph 78 of Gray, even if the sentence is not regarded as being a punishment, it does not mean the judge was treating the claimant as not being to blame for what he did. A conviction for manslaughter still involves blame. Some responsibility for the killing still necessarily remains. Moreover, the fact of the criminal conviction is in itself punitive. And interestingly, this is a point that's picked up by Lord Dawson in Tell and Mercer, paragraph 29. Sorry, yes, paragraph 29, which is page 727. He also notes that it had to be assumed, looking at Gray, that the sentence was what the criminal court regarded as appropriate to reflect Mr. Gray's personal responsibility for the crime. It's therefore right to apply the rule that he could not recover damages for the consequences of the sentence, reflecting an underlying policy based on inconsistency, requiring someone to be compensated for a sentence imposed because of his personal responsibility for a criminal act. And there is another point I just pointed out to you, so I'm conscious of time, but the fact of an acquittal from a charge of murder on the basis of not guilty by reason of insanity does not automatically lead to a hospital order with a restriction. It does not automatically lead to detention. I think it's probably important just to look at this, because I'm not sure whether this was completely understood yesterday. I'm not saying that my learned friends would understand it, but I'm not sure whether this came across yesterday. If we go to tab 3, page 12 of the electronic manual, and look at the Criminal Procedure Act, section 5.3, or section 5. The subheading for the section is powers to deal with persons not guilty by reason of insanity or unfit. It's dealing with those situations.
So sorry, which page?
Sorry, it's page 12 of the electronic manual.
Yes, thank you. Okay, I have it.
So section 1A, this section applies where a special verdict is returned that the accused is not guilty by reason of insanity. And then you go on to 2. The court shall make in respect of the accused a hospital order, brackets with or without a restriction order, B, a supervision order, or C, an order for his absolute discharge. Subsection 3, where the offence to which the special verdict relates is an offence for which the sentence is fixed by law, murder, and the court have a power to make a hospital order, the court shall make a hospital order with a restriction order, whether or not they would have power to make this apart from the subsection. So that what is required before a hospital order follows, it is firstly it's murder, the sentence is fixed by law, and secondly that the court have power to make a hospital order. Where the court do have power to make that hospital order, and it is relates to a case where the charge was murder, then they must also impose a restriction order.
So just from my education, where does the court's power to make a hospital order, as referred to in 3B, come from?
It comes from section 37 of the Mental Health Act, which is at tab 4.
Yes.
And take you to that.
Well, I'm sure it's obvious to everyone else.
And also you've got subsection 2. Subsection 2 of section 5.
Yes. Did I not read that?
Yes, yes, but that's where you've got not guilty by reason of insanity. By section 5, subsection 2, there's a power to make a hospital order.
So just to spell this out, you can have rare but genuine cases where someone is temporarily insane for some physical reason, maybe they've been given the wrong medication, or they have some curable physical thing which has had an impact on their sanity, so that by the time of the trial they are completely cured, but they were unquestionably also insane at the time of the trial and at the time of the offence, and have been given a special verdict on that basis. In those circumstances, I've always understood that they could be absolutely discharged. And there's nothing here that's inconsistent with that, is there? Because that wouldn't be a case where a hospital order could be made. because at the time of the hospital order being made, you have to be suffering from some mental condition.
Yes, or of a nature or a degree. And
Quite.
so on, and we can come
Quite.
to that, and even if the charge was
I'm not
murder,
quite sure this is the point you're getting at, but if all you're saying is that there's no obligation to make a hospital order, that's obviously right.
So well, I think I wasn't sure if that had come across yesterday. There isn't an obligation to make a hospital order unless Section 37 is satisfied of the Mental Health Act, and in this case it was, no question. I'm not suggesting otherwise.
No, it's simply an illustration of the fact that it's a genuine verdict of not guilty.
Yes.
You might not have any sanction at all.
And that you could have set of circumstances, as you were to describe, with the physical ailment that made you lose your sanity for that period of time. Or you could have a situation where it becomes the case that your schizophrenia is in remission and you are no longer of risk factors. So the nature and the degree would be looked at. So you can imagine a case which is tried some years later, for example. But just to take you to Section 37 of the Mental Health Act, because I think this is important. The conditions which are required before the order can be made, and this is at page 30 of the electronic download, so it's 37.2, are that the court is satisfied on the written or oral evidence of two registered medical practitioners that the offender is suffering from a mental disorder, and that either it is of a nature or degree which makes it appropriate for him to be detained in hospital for medical treatment, and appropriate medical treatment is available for him. And then this is a separate case, in the case of an offender who is detained to the age of 16. A must have a mental disorder which makes it appropriate for him to be detained for medical treatment, and that treatment is available. And B, the court is of the opinion, having regard to all of the circumstances, that and to the other available methods of dealing with him, that the most suitable method is by order under this section. The power, when I did my submission, comes from the Section 37 of the Mental Health Act. And there isn't a separate power by virtue of the Criminal Procedure Act to make a hospital order which enables the court to do that without regard to the medical evidence and to the state of the claimant's health and availability of medical treatment. And the reason that, in order to assist you to see that, what happened was as a result of the Criminal Procedure Insanity Act 1964, the outcome of an insanity, not guilty by reason of insanity verdict, was hospitalisation. It just followed. The 1991 Criminal Procedure Insanity and Unfitness to Plead Act amended that and introduced a range of disposal that could follow an insanity act. But they did not apply at that point in 1991, where the offence charged was murder. And that was changed as recently as 2004. And the Domestic Violence Crime and Victims Act 2004 provides that where the sentence for an offence is fixed by law, the courts now have power to order a hospital order only if those necessary criteria in Section 37 are satisfied.
So was it the position until then that in the kind of unusual but perfectly possible case we've been talking about, someone who was perfectly well had to be subject to a hospital order? Was that really the law before 2004? There's no doubt why they changed it.
And because it reflects, I would say, current understanding of mental health and of the lack of, there is no culpability, the lack of the fact there isn't a punishment inherent in the fact that there isn't an automatic punishment follows or restriction on your liberty which follows. It truly is the case that a hospital order is only made if and for the sake of your mental health. There's an explanatory note which accompanies the Domestic Violence, Crime and Victims Act 2004, which sets that out in a little detail, and I hope copies have reached them.
Yes, thank you.
But the acquittal, the fact that the acquittal led to a hospital order with a restriction in this case cannot mean in that position that the acts retrospectively become tertiary. It becomes culpable for them. What of those who are absolutely discharged? What of those who are no longer suffering the mental disorder of a nature or a degree? Is it the fact that this person was more ill for longer that makes his acts tertiary? Is it the fact that he still required treatment in hospital by the time he came to trial that makes his acts quasi-criminal? It can't be right. There isn't an automatic restriction. The defendants place weight on the restriction order, and there is an automatic restriction in that respect. If a hospital order is made, then pursuant to Section 37, or having satisfied the requirements of Section 37, then it has to be accompanied by a restriction order pursuant to Section 41 of the Act. And as a result of that, the patient can no longer just be discharged by the responsible clinician without involving the Secretary, well, the defendants say without the consent of the Secretary of State. To be fair, that's not quite right. His discharge from hospital is not necessarily dependent on the views of the Secretary of State. The Act also ensures that there's a periodical review by a mental health tribunal as to the lawfulness of the ongoing detention, and the ongoing detention is only satisfied under Section 37 if the patient still has a mental disorder of a nature or a degree which makes it appropriate for him to have the treatment. And Section 73 of the Act enables the Mental Health Review Tribunal, when undertaking their periodic reviews or when the patient is entitled to apply to them, to discharge him absolutely. It's not subject to the consent of the Secretary of State. It is right to say that the Secretary of State is invited to play a part in those hearings. I think made a part, he can put comments, but as with any other witness, it is a decision for the tribunal as to whether or not the lawful reasons for detention are ongoing. The role of the Secretary of State, in other words, they can put in some comments in relation to health and to their own view of risk and so on, but it's entirely distinct from issues of criminality. It's not taking a punitive role. It's addressing the criteria set out in Section 37 at the time when those tribunals happened. So the role of the Secretary of State is distinct from questions of culpability and criminality, and his concern with public safety. I just noticed the time. I come to the end of this part of my submissions relating to the criminal law and the status of Mr. Lewis-Ranwell. I hope you've got the thrust of my submissions. It would be inconsistent with the statutory provisions and with the criminal law to find him to be morally or legally responsible and to attach that to him. And to bar a claim in a case such as this would be just as incoherent as it would be to allow one an exemption responsibility.
Right. All right. Thank you very much. We'll see you again at 2.
All right.